Hi, I'm attorney Stephanie Trinkle. Welcome to Video FAQ, where I take some time to answer some questions that come up a lot from clients and help explain some basics of estate planning so you can feel comfortable knowing what you're getting, what you're buying, and the decisions that you're making. So the first thing I want to talk about is what is a will and how does it work? So what a will is it's essentially a list of instructions that you're leaving for what you want to have happen to your estate and your property after you pass away, and who gets what and when. Now, in your will, you always name someone to be your personal representative. This person is also called an executor, depending on what jurisdiction you're in. And this is the person that's going to be responsible for handling your affairs after you're gone. They're going to file your will with the court, and then they're going to work under the court's supervision to make sure that the instructions that you left are followed, and distributing out your assets and filing the paperwork with the court. Now, a will is a document that only works in the context of a probate proceeding. And this is a huge misconception, and I hear this all the time. And it's, well, I don't have to go to probate because I have a will. That's actually entirely false. If you are using a will as the main foundation for your estate plan, you are absolutely going to go to probate. That is the only way that a will works. So it's something to really take into consideration. And I get into the details of what probate is and how that works exactly in another video. But for the purposes of this discussion, I just want you to know that if you do have a will and no other documents like a trust, then your estate will go through probate. Now, a will also only works and only has authority during the duration of that time of the probate proceeding. So if you've become incapacitated, maybe you've had an accident, but you're still alive, your will does nothing. Maybe you've named a guardian for your kids in your will, but again, maybe you're just missing, or you've suffered a really bad injury. Your guardianship nomination, if it's in your will, at that point is worthless. Your will only has authority after you've died and during that court probate process. Once the probate is finished, then your will is essentially deemed to have fulfilled its purpose, and the instructions that it's left are complete and really don't carry any weight unless you've set up a trust through your will. So that is what a will is. I hope that's helpful to help understand this basic document. It is an important part of every estate plan. Every plan should have a will as a piece of the overall plan, but it's really not the best way to structure an estate plan on its own. Again, because it's limited in what it can do and the time that it can do things, and it lands you in court. So if you have any concerns about being in court, a will is not the way to go. So I hope this has been helpful. If you have any questions, please send me an email or give me a call. I'm happy to help.